dirty, 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 dirty pool by the United States Court of Appeals for the Ninth Circuit yet again when it comes to our Second Amendment right to keep and bear arms. You're not going to believe what they did this time. The good news is that Judge Lawrence VanDyke on the Ninth Circuit dissented from what just occurred, and Lawrence VanDyke may very well be the next U.S. Supreme Court nominee by President Donald Trump. Let's break all of this down when we get back. You're going to be shocked, but in some ways you won't be shocked because it's the Ninth Circuit, and you know they're always up to games when it comes to infringing on our right to keep and bear arms. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon. If you already have a book, feel free to leave a review on Amazon as well. All right, breaking news. The United States Court of Appeals for the Ninth Circuit out of California in a case of United States versus Perez Garcia, there's actually consolidated cases here, but you don't need to worry about that, has just played dirty pool when it comes to our Second Amendment rights. To explain what happened here, I want to remind you all that under the United States Constitution, Article 3, federal courts are only allowed to hear cases that are live. What that means is they have to be actual cases or controversies. The reason why that's important to what I'm about to explain is this. In federal court, if a case becomes moot, then the case is no longer subject to the federal court's jurisdiction and it's to be dismissed. Now, a case becomes moot when it's no longer a live controversy. Something happens, someone dies, the issue's over or it's passed, whatever it is. If a case becomes moot, then federal courts, as a general matter, lose jurisdiction over the matter and they cannot make decisions on the matter because federal courts are not allowed to issue what are known as advisory opinions, which is just telling people what they think for the sake of letting people know what they think. That's not how the system works. Now, with that backdrop in mind, here's the dirty pool that the Ninth Circuit just did to mess with and take away our Second Amendment rights. In this case, United States versus Perez Garcia, the question presented was, to what degree can the government infringe on our Second Amendment rights and take away the right to keep and bear arms in the context of what's known as pre-trial detention or conditions on bail? What do I mean by that? People are indicted and charged with crimes all the time in the United States. Some are serious crimes, some are not so serious. So the question becomes, when can that person who's been charged with a crime be disarmed under the Second Amendment between the time he's indicted or charged with a crime and the time he's actually tried on the issue of whether or not he or she committed the crime? During that window of time between the charge and the trial and resolution of the case. That is often referred to as pretrial detention or pretrial conditions on bail, pretrial conditions on release, supervised release, whatever you want to call it, that period of time. Now, in this case, there were two individuals who were charged with drug-related issues. We don't need to get into the details. It's not that important, but they were both charged. And as a condition of being released from prison between the time of the charge and the trial, they both had to give up their right to keep and bear arms. Now, this was a huge problem for Mr. Perez Garcia because it turned out to be he was a security guard and carried a gun as part of his job. So when he was required to give up his right to keep and bear arms, he lost his job as a security guard because he could no longer carry a gun. So he lost that job and was forced to take a less well-paying position. So he argued that this violated his Second Amendment rights to the federal district court, to the trial court, and the judge denied it and says this restriction on your right to keep and bear arms does not violate the Second Amendment. And here's where the dirty pool comes in from the Ninth Circuit. Ready? Here's what happens. An immediate appeal is taken to the Ninth Circuit Court of Appeals to say that I am losing my right to keep and bear arms. I'm not dangerous. I'm not a violent threat. I've never been found to be any of such. This violates my Second Amendment rights. So oral argument takes place in January 2023. And what happens that afternoon? On the very same day is that the three-judge panel issues an order, not an opinion, but an order that says that the defendant's Second Amendment arguments fail and are rejected. And that the three-judge panel, in this order, concludes that there is no basis for claiming there's a violation of the Second Amendment here. Now, Why is that order important? Between the time of that order and March of 2024, hear what I just said? Oral argument on January 2023. In March of 2024, the three-judge Ninth Circuit panel issues a long, 60 some odd page opinion laying out all these arguments against the Second Amendment. Now, what happened between January 2023 and March of 2024 is that the two cases that were involved with this appeal, including Mr. Perez Garcia's, had become moot because one individual had been convicted, the other individual was essentially disappeared. No, it doesn't matter. The bottom line is, between January 2023, the oral argument, and March of 2024, the two cases that were involved in this appeal had become moot. But what happened was that the Ninth Circuit panel claimed that because they issued an order in January 2023, at the time the case had not yet been moot, even though the order said virtually nothing of merit or substance, it was just an order that says, we reject it and we're going to issue an opinion later, they then wait over a year to write this magnus opus, right? This magna opus against the Second Amendment over a year later, after the case had already been moot. But remember what I said at the start of this video. When a case is moot, the courts lose jurisdiction as a general matter. So why was this panel able to write this massive anti-Second Amendment opinion in over a year after oral argument and long after the case had been moot? And their argument was because they issued that order, a short order explaining that they rejected the defendant's arguments, it gave them a hook legally to explain why they issued that order. That is dirty pool. Now, it gets worse. So now they say, well, the case is moot at the time we issued the opinion in 2024, but when we issued the order that just said in a few sentences, the Second Amendment loses, that allows us to explain our decision even if it's a year later. And mootness doesn't come into play because all we're doing is explaining why we issued the order. And when we issued the order, the case had not yet been mooted. See the game there? But it gets worse. So then the defendants sought an en banc review. Hear what I just said? An en banc review by the entire Ninth Circuit, which in the Ninth Circuit is not the entire Ninth Circuit, it's the bulk of the Ninth Circuit. No need to bore you with those details right here. But the defendants sought an en banc review saying that this is wrong, this did violate the Second Amendment, and so on and so on. But guess what happened? And this is another example of dirty pool by the Ninth Circuit. The en banc Ninth Circuit came out and said, because the case is now moot, we deny the en banc appeal. See what just happened? The panel wrote a massive anti-Second Amendment opinion laying out all these terrible reasons why the Second Amendment is wrong and how to screw people out of their rights when it was moot, but they claimed that the hook from the order allowed it not to be moot so they could write the opinion. But then when they sought en banc review to reject and overturn and vacate that 60-page anti-Second Amendment screed by the panel, the en banc court of the Ninth Circuit says, we're not going to touch that. Why? Because the case is now moot. So they use mootness as a sword and then a shield. Now, the good news is that Ninth Circuit Judge Lawrence VanDyke called them out and said this was dirty pool for all intents and purposes. And here is what Judge VanDyke wrote about this game, this dirty pool by the Ninth Circuit. Judge VanDyke wrote, quote, we should have taken this case en banc for the limited purpose of vacating the panel's opinion. Doing so would have been appropriate to wipe the slate clean for another case, one in which the government, not the panel, carried the government's burden to resolve the historical analogy analysis and determine how Rahimi affects our existing case law. By electing not to do so, the panel's opinion injects many substantive errors into our, meaning the Ninth Circuit's, jurisprudence. Very powerful stuff from Judge VanDyke. What he's basically saying is the Ninth Circuit should have taken this case en banc and at a minimum vacated that 60-some-odd page opinion that came in 2024 that explained the order entered on the same day as oral argument in January 2023. And that is what Judge VanDyke explained. And then he goes on to explain just how terrible this really is. This is what he writes next. What makes the panel's opinion particularly troubling is that it went out of its way to decide an unnecessary issue with potentially broad implications in a moot case. The panel needlessly analyzed our tradition of disarming dangerous citizens, dangerous individuals, shortly before Rahimi was poised to do the same. So you see the game that just got played here? The Ninth Circuit panel wrote this 60-some-odd page crazy anti-Second Amendment decision. And then, when it was time to review it en banc, they conveniently did not do so. Now, Judge VanDyke also points out that if the shoe were on the other foot and a 65-page opinion had been written in favor of the Second Amendment rights, there's no doubt in his view that the Ninth Circuit en banc would have skipped over the mootness question and would have granted en banc review to, at a minimum, vacate that panel's decision. So again, here is another example of the Ninth Circuit playing games to make sure that people in the Ninth Circuit don't have Second Amendment rights. It's pathetic. It's terrible. And just to show you the 2 points made by Judge VanDyke on the merits of why the 60-some-odd page anti-Second Amendment opinion by that 3-judge panel was so terrible, 2 key points to keep in mind. As you know from the Bruen case, and Heller, but in particular Bruen in this instance, the burden of proof to come forth with historical analog gun control laws from the time of our founding lies with the government, not the courts, the government. It's up to the parties to prepare and argue the case. It's not for the courts to do their job. This was crystal clear and made crystal clear by the U.S. Supreme Court in Bruen. It's up to the parties. Here, the Department of Justice did a terrible job in coming forth with historical analog laws in this case. So what exactly did the dozens and dozens and dozens of anti-Second Amendment historical arguments, where did those come from in this panel decision? The answer is the panel went out and did their own historical research to throw Americans under the bus. So rather than relying on the relatively weak presentation by the United States government and Merrick Garland's Department of Justice, this panel spent over a year. Remember, the oral arguments in January 2023. The opinion comes out in March of 2024. That's over 12 months. They spent doing all the work as if they were the lawyers to come up with reasons why these gun control laws are justified and the Second Amendment is not violated. So that's the first rule that Judge VanDyke points out. And by the way, Judge VanDyke is 100% on the short list to be a potential Supreme Court nominee by President Trump. If Donald Trump is elected, Judge VanDyke will definitely be in serious consideration for a Supreme Court pick. I think there's about 10 people. We're going to do a separate video on those, but I'm just letting you know that Judge VanDyke is definitely on that list and will definitely be considered by President Trump if Donald Trump's elected. So that's what we're talking about here, the dissent in favor of the Second Amendment by Judge VanDyke. Okay? So let me get back from that digression and focus on the second mistake that the panel made that was clear. In addition to basically doing all the work for the government, because the government had done a terrible job, presumably in the panel's opinion, that's why they did all this extra work. The second thing was that they screwed up a basic premise of Rahimi. Now think about this. What is one of the best things that came out of the Rahimi decision dealing with the constitutionality of 18 U.S.C. 922 G8, right, was this, that a person that is found to be dangerous can be temporarily disarmed if they're physically dangerous, if they're found to be physically dangerous by a court, okay? But the real thing that came out that was very, very powerful in favor of the Second Amendment was this. The Chief Justice John Roberts' opinion that was also concurred with essentially by, on this point at least, by the dissent of Clarence Thomas. 9-0 said that you cannot disarm Americans simply because you consider them to be irresponsible. Hear what I just said? That's what the Rahimi case literally said in the majority opinion, that just because someone is not responsible is not a basis to disarm them. Yet here we have the Ninth Circuit panel in the Perez Garcia case after 14 months of work against the Second Amendment, literally talked about how the reason why they can take away the Second Amendment rights from people between the time they're charged with a crime and the time they go to trial on that crime is because they are viewed to be not responsible. Directly contrary to the Supreme Court decision in Rahimi that came out in June of 2024. Another reason why this dissent from the denial of en banc review by Judge VanDyke points out why this panel decision should have been vacated by the en banc. And keep in mind, the issue here was that the en banc Ninth Circuit should have looked at this panel decision and said, this is moot. This is talking about a lot of issues that the government didn't do a good job at. You know, you went over what you got over your skis. You said a lot of stuff that's inconsistent with Rahimi. So we, the Ninth Circuit en banc, we're going to vacate and mean it's no longer good law, that panel decision that came out in 2024. And they had a whole bunch of reasons for doing so, but instead they said we're not going to do it on the grounds of mootness, which allows that terrible anti-gun 60-some-odd page opinion by the panel to stand and continue to be binding law in the Ninth Circuit. That's why it's dirty pool all the way around in my view. Again, no shock, the Ninth Circuit is known for this, but I wanted to bring this to your attention. I'll put a link to it down below. By the way, Judge VanDyke also does a very powerful job. He cites to a very handsome YouTuber with actual, authentic, real hair. Yes, Mark Smith, I think, is cited. I think I'm cited in the first footnote. I can't remember which footnote, but I'm definitely in the opinion. So, yeah, obviously we know that Judge VanDyke gets it right if he's, citing to a handsome YouTuber, Mark Smith. Anyway, there you have it, folks. Hope you enjoyed today's video. Make sure you subscribe. Don't forget to follow me on X at 4 Boxes Diner, and we will talk to you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.